In England, by a series of legal decisions from 1664 to 1699, this problem for commerce was remedied by making bills of exchange enforceable by third parties. If a third party had purchased a bill for valuable consideration and in good faith, having no apparent reason to suspect fraud or some deficiency in the right of the seller to sell it, then the bill automatically became good and enforceable by the court against the signer. What did this change mean? It meant, essentially, that any bill of exchange would be considered legitimate once it was sold. Bills of exchange and all other subsequent types of signed promises to pay, with the notable exception of checks, became transferable and enforceable in court, just what the merchants wanted. Now debt contracts could be sold like things, and transacting business would be a whole lot easier. Not only that, it opened up a whole new market for profit seekers, trading in bills of exchange themselves. The marketing of debt was born. The change in the law had another effect as well. It made it possible to trick or even force a person into signing a legally binding promise to pay, and then, if that promise were purchased by a third party for real consideration and in good faith, it would be enforceable against the signer in court. Ultimately, this became one of the foundational principles of the Uniform Commercial Code, which governs the conduct of business in the United States, and by extension, in most of the world. Think about it. If we buy a stolen laptop from a guy on the street, we're guilty of receiving stolen goods, a criminal offense. Doesn't matter if we paid honest money and were unaware the goods were stolen. The court will restore the goods to the rightful owner. We, as purchasers, innocent or not, lose our money and may even be charged with a crime. But if we buy a loan contract from a banker and give him real value for it in good faith, it doesn't matter that the loan contract may have come into existence under false pretenses. Whoever signed it is required by commercial contract law to pay up, and the courts will enforce the obligation. Today, debt contracts come in a myriad of forms, including and especially loans and mortgages. It's significant to note that just as these common law restrictions were being removed, the brand new Bank of England was being established. The first bank state-authorized to create money out of thin air. The new laws fit in perfectly, making the new bank's empty contracts enforceable against the so-called borrower. Those who have discovered the true nature of their own bank loans and have attempted to challenge the validity of their debt contracts in modern courts have discovered to their dismay that this commercial contract law is still the bedrock defense of money as debt. The bank will have sold the original loan agreement to a third party for value, and even though that third party is often just a sister company of the bank, all that matters to the judge is who possesses the document, what it says, and whose signature is on it. The bank's failure to inform the borrower about the true nature of the loan contract and the absence of any actual money loaned on the bank's part is not relevant.